Good afternoon, everyone. Welcome back from the long weekend. Happy Thanksgiving to those who celebrated. Happy New Year. My name is Peter Neufeld. I'm a partner at the firm Wagner Sidlofsky. I'm the co-chair for this Lunch and Learn series on the issues in family law and estate law, along with my colleague, Professor David Freedman, who will actually be one of the co-presenters today. The subtopic that we are speaking about is an update rather on the treatment of trusts in equalization claims. We have two papers that were prepared in advance of today's seminar on this topic, and PDF copies can be found in the Zoom chat.
The proposed Canadian Entrepreneurs Incentive.
Just a few housekeeping notes. Please make sure that you have your microphones muted at all times. Unless, of course, you're asking questions at the end of the presentation, after which we ask that you mute yourself again. Please also note that this seminar is being recorded. There will be a certificate of attendance that will be posted in the chat momentarily to confirm your attendance for you and which you can download from the chat. We have two presenters today, Professor David Freedman and Kristy Warren. David Freedman is a professor at the Faculty of Law at Queen's University and counsel at Wagner Sidlofsky. He teaches and writes in the areas of wills, estates, trusts, and guardianship law. Kristy Warren is a lawyer at Epstein Cole. She is a knowledge management and practice support lawyer there. She practices exclusively in the area of family law and provides support to the firm's lawyers in their practices. She is an editor of the Reports of Family Law and assists with Franks and Zaliv This Week in Family Law, which is a highly read weekly family law newsletter that's published on Westlaw. Thank you to our sponsors, in particular, Scotia Wealth Management, the Brith, Epstein Cole, Concentra Trust, BMO Private Wealth, TD, Torque and Mains, Solos Trust, as well as Weirfolds. This event is complimentary because of them. If you've enjoyed our seminar or if you've enjoyed previous seminars, we ask that you consider making a donation to the B'nai Brith. If you haven't already, the link for that is in the chat. We have Elite Mannheim here. She is a manager of legal affairs at B'nai Brith Canada, and she's here with us today to tell us a bit about the organization and its charitable work. Go ahead, Elite.
Good afternoon. I'm actually going to speak today for a few short minutes about the rising anti-Semitic incidents that we recently came across. So reports of anti-Semitic incidents in Canada have reached a record high since last year's Hamas attack on Israel. Since October 7th, 2023, the Jewish community haven't had a single moment of relief. Instead, we faced a shocking number of anti-Semitic threats and experienced calls for more violence against Israelis and Jews everywhere. The war inspired a wave of demonstrations across Canada. One of B'nai Brith Canada's mandates is to nationally combat anti-Semitism and racism in all its forms. We research and track individuals who display anti-Semitism and racism, whether in person or online, whether it's harassing in nature, vandalism, or violence. When we encounter such racist or anti-Semitic individual, we investigate and do a deep dive into their activities to research and track these individuals' display of hate. Before we proceed with sending letters of complaint to these individuals, employers, and or licensing bodies, we make sure to do a thorough due diligence. For example, last week, just before Yom Kippur, B'nai Brith has exposed Dr. Barry Lavely, I hope I'm saying his name correctly, I'm sorry, a licensed physician in Manitoba, which has unleashed vile and anti-Semitic hatred online, betraying the trust of the public and tarnishing the medical profession. His despicable statements glorify violence against Jews, deny their right to self-determination, and invoke dangerous conspiracy theories aimed at dehumanizing an entire community. B'nai Brith Canada has filed a formal complaint with the Colleges of Physicians and Surgeons of Manitoba, demanding immediate action. A physician who promotes such grotesque hatred has no place in Canadian society, let alone in the medical profession, where he's entrusted with the care and well-being of others. Brith will not stand by as hate continues to spread unchecked, especially from those whose professional obligations require them to adhere to the highest ethical standards. We called on the College of Physicians to act swiftly to send a clear message that there is no room for hate in our healthcare system and no tolerance for those who spread division and fear. Thank you.
Lee, thank you very much for that. Okay, we're going to go ahead and start with the main part of the presentation today. Again, the topic is an update on the treatment of trusts in equalization claims. David Freedman is going to start us off. Take it away, David.
Thanks very much, Peter. Welcome, everyone. The topic that we have for today is actually a really interesting one, I think. The intersection of trust law with other areas of law tends to throw up interesting problems. And in part, I think that's because trust law it takes great care to delineate the rights and the obligations of trustees and the rights of beneficiaries. And on the whole, this is in part to protect trustees from interference by beneficiaries who seek to take an advantage, and at the same time try to protect the trustee from becoming embroiled in a dispute amongst the beneficiaries. Obviously, the beneficiaries can bring matters into court for supervision by the court, but the nature of trust law and the division between legal rights accruing to the trustee and beneficial interests accruing to the beneficiaries tends to favor trying to have really a strict approach to what we expect of trustees. And if it were otherwise, it would be difficult for anybody to ever agree to become a trustee of a trust. So as a matter of trust law, we tend to be very concerned with the integrity of trusts and with the integrity of trusteeship. So I have prepared a very, very short paper, and it doesn't really deal too much with the intricacies of family law. Luckily, we have an expert with us and who's going to lead us through understanding how family law takes account of trusts. But I would like to say something at the outset about sham trusts. There are three areas that tend to be of concern traditionally with respect to sham trusts, and that is in respect of income tax avoidance or attempting to avoid creditor claims on insolvency or bankruptcy, and in family law. And so in the short paper that I prepared, I spent a little bit of time looking at some of the principal sources. But I just do want to make the point that sham trusts are not real trusts. I mean, they're not trusts at all, really. And perhaps the best contemporary example of this is the judgment of the Federal Court of Appeal in a case called Antle in Canada. And I've given you the cite to that on page 2 of the paper if you want to look it up. This is a really simple case. The owner of corporate shares in a smaller business settles a trust in the Barbados, transfers the shares to the Barbados. The trustee there makes an undervalued sale to the settler's wife. The settler's wife then sells it at fair market value, and then attempts to have the proceeds of the sale be a subject of a loan agreement between her and the settler, essentially to bring the proceeds of sale back into Canada, but to avoid the capital gains tax on the disposition of the shares. And the CRA objected, and it went to the Federal Court of Appeal, and the Federal Court of Appeal said it was a sham trust and wasn't real. And the reason is, and you get this a lot in these sham trust um, situations. The settler creates the trust with his property, and there's a coloration of a trust. It looks like there's a real trust in the Barbados with a real trustee, but the trustee is really an agent. I mean, just an agent for the settler. The settler controls the trust. The trustee is not making independent decisions. The trustee is just following what the settler wants. And that's just a form of agency. And that's not a trust at all. And so it's a sham. It's a coloration for a trust. And in that case, it's a impermissible way to try to avoid tax. So I don't want to belabor the point, but I do want to comment on the kinds of red flags that commonly arise in these sham trust cases and why you might want to be on alert for them, regardless of whether it's family law. I mean, it also could, as I say, arise in insolvency practices as well. And there's some really big ones that are kind of obvious. There's no commercial logic to using a trust. That's often the case. Or there's no written trust agreement. Or if there is a written trust agreement, it postdates the settlement of the trust, usually by a fairly long way. There's no segregation of trust funds, or if there's a family trust, everybody seems to have access to the trust. Or the trustee doesn't file income tax, or the trustee mixes the trust funds with his or her personal funds, or the trustee makes advances to themselves. In other words, in dealing with trusts, we're always on the lookout for the use of the trust concept as a way to avoid obligations. And it's usually fairly apparent that there's not a real trust from the manner in which the trust is supposedly controlled by the trustees and the beneficiaries. It doesn't comport with the kinds of obligations that we would find normally incumbent on somebody administering an estate or administering a conventional trust. And so with that in mind, we can then turn to how trusts proper trusts are accounted for in different areas of law. And perhaps the most interesting example is family law, because family law has a very developed, complicated, predictable, stable model of law that we use all the time. And family law has intersected with trust law in a way that sometimes drives trust lawyers a little bit crazy. But on the other hand, I think that the doctrine that has been developed is quite pragmatic and fits well within the objectives of family law. And with that in mind, I would invite my colleague Kristy Warren to tell us about equalization and how trust interests are dealt with.
Thanks, David. So to start with, I appreciate that this will be a bit of a refresher for the family law lawyers in attendance, but I appreciate that there are a number of estate lawyers in attendance who may not have had to think about the equalization process since studying for the bar exams. So I'm just going to go through and do a very brief overview of the equalization process and what that looks like before getting into how trusts are treated within that process. So first of all, to start with, in Ontario, it's the Family Law Act that provides for the division of the value of property owned by spouses on the breakdown of a marriage. So it's important to keep in mind for the purposes of this discussion that even though the Family Law Act refers to both married spouses and common law spouses, it's only married spouses who have the right to the division of property under the Act. So for the purposes of today's discussion, we're only really talking about married spouses. Unmarried spouses, in terms of asserting any sort of property rights, would have to look to unjust enrichment, resulting trust, and constructive trust claims, which are outside the scope of today's presentation. So this process of the division of property is referred to as the equalization process. And it starts with each spouse completing what we call a family law financial statement, which is essentially a detailed net worth statement. And the Family Law Act requires that they list all property on the date of marriage, on the date of separation, as well as the value of that property. And the Act defines property very broadly as any interest, present or future, vested or contingent in real or personal property. So you can already start to see how this may cause issues or complications when we're dealing with future or contingent trust interests. So once each spouse has completed their net worth statement, we calculate the change in each spouse's net worth during the marriage by deducting the value of their net worth on the date of marriage from the value of their net worth on the date of separation. And the change in their net worth during the marriage is referred to as their net family property. And then to complete this equalization process, the spouse with the higher net family property, so in other words, the spouse whose net worth has increased more during the marriage, they pay the other spouse 1/2 the difference between their respective net family properties. So for example, if spouse A's net family property is 100,000 and spouse B's net family property is 50,000, spouse A would pay spouse B $25,000 to equalize their net family properties. And this payment is referred to as the equalization payment. So for the purposes of our discussion today, it's important to know and keep in mind the difference between a deduction and an exclusion in the equalization process. So when I was explaining the equalization process a few minutes ago, I mentioned that the value of a spouse's net worth on the date of marriage is deducted from the value of their net worth on the date of separation. And it's for this reason that we refer to property owned on the date of marriage as a deduction. So just to give a very simple example, if a spouse owned a painting worth $100,000 on the date of marriage, and it had increased in value to $150,000 on the date of separation, they would be entitled to deduct the $100,000 when calculating their net family property, but would be required to share the $50,000 increase in the value of the painting during the marriage with the other spouse. So in addition to deductions, the Family Law Act also provides for some exceptions to the equalization process, which we refer to as exclusions. And these exclusions are completely excluded from the calculation of the net family property, and as a result are not required to be shared with the other spouse. So the Family Law Act sets out a list of the property or types of property that is to be excluded from the calculation of the net family property. And that list of property includes property other than a matrimonial home that was acquired by gift or inheritance from a third person during the marriage. So this could include, for example, a beneficial interest in a trust that was acquired during the marriage from a third person. But it is very important to keep in mind that it is the timing of when the spouse receives that beneficial interest in the trust that is important. So if they receive that beneficial interest, in other words, if they were named a beneficiary of the trust before the marriage, they would only be entitled to deduct the value of their interest on the date of marriage in the calculation of their net family property. And they would be required to share the increase in the value of their interest during the marriage, along with any distributions received during the marriage with their spouse. So again, they're only receiving that date of marriage deduction and are required to share any growth or any distributions during the marriage. However, if they receive the beneficial interest in the trust during the marriage, as opposed to before the marriage, they will actually be entitled to exclude the full value of their interest in the trust, along with any distributions from the trust from the calculation of their net family property. There are some exceptions to this, one of which I alluded to earlier, which is that if the excluded property or distributions from the property is traced to a matrimonial home, which is essentially the family home, you lose the exclusion once it goes into a matrimonial home. But I won't go into too much more detail on that for the purposes of today's discussion, but it's important to keep in mind that there is the potential to lose that exclusion over the property. So again, when we're dealing with trust, it's important to keep in mind that the relevant date for the purposes of determining whether the property is treated as a deduction or an exclusion is the date on which the spouse is actually named a beneficiary of the trust. It's not the date that they receive a distribution from the trust. So there is a case from 1988 called Black and Black, where the court considered this, where essentially a husband had received an interest in a contingent trust before marriage, but had not actually received the trust property until after he was married, and he tried to argue that it was excluded property. And the court said, no, the date that matters is the date that you were named as a beneficiary or a contingent beneficiary of this trust, not the date that you actually received the shares held by the trust. And therefore, it's only a date of marriage deduction, and you have to share the increase in the value of that property during the marriage with your spouse. So now we'll get into more detail about how trust claims or trusts work within the equalization process. So the first question is, if a spouse has a beneficial interest in a trust that they've received before marriage, the question is whether that interest is property within that definition set out in the Family Law Act, which again is quite a broad definition of what constitutes property. So that's the first question to consider. If it is considered property, then the second question, of course, is how to go about valuing that property or that interest in the trust. So first, we'll talk about when a beneficial interest in a trust is property and when it might not be property. And while I would love to be able to give you a more definitive answer to this question about whether a spouse's beneficial interest in a trust is property under the Family Law Act, the unfortunate reality is that the answer to that question depends on the circumstances of the trust at issue, including the spouse's ability to directly or indirectly control the trust and distributions from the trust. So one decision that's very helpful on this issue is the 2016 decision called Tremblay and Tremblay, and the citation for that case is in the one paper. And in that case, Justice Phillips dealt with this issue and dealt with the issue of how do you determine whether a beneficial interest in a trust is property under the Family Law Act and is therefore subject to the equalization process, or is not property. And so Justice Phillips noted, and this is picking up on what David was talking about earlier, is that under trust law principles, the only interest, all that a beneficiary of a discretionary trust has is an expectancy. So an expectancy to receive something under the trust, but they do not have actually any concrete interest in the property held by the trust. However, as we know in family law, so the analysis doesn't end there, and it's not quite that simple. So what Justice Phillips notes in Tremblay is that if the beneficiary has a certain amount of control over the trust, including the distributions from the trust, that may elevate their expectancy into something more like a certainty. So again, the focus of this analysis is on the level of control that the beneficiary has over the trust. And that will, in large part, inform the question of whether or not their interest is property to be equalized or not. So in Tremblay, Justice Phillips helpfully set out a non-exhaustive list of factors that the court can consider when assessing the degree of control that a beneficiary has over a trust. So I will just quickly run through those factors, but again, they're set out in the paper that's been provided. So first, any evidence with respect to the founding intent of the trust. Second, the composition of the trustees, including whether the beneficiary is a trustee. Third, any requirement, including veto powers, that the beneficiary be part of any trustee decisions. Fourth, any history of past trustee actions that demonstrate direct or indirect control by the beneficiary. Fifth, any powers of the beneficiary to remove trustees or to appoint replacement or additional trustees. And finally, the relationship of the beneficiary to the trustees. So that's not to suggest that if there is a familial or close relationship between the beneficiary and the trustees, that the beneficiary will be determined to be in control of the trust. But it is one factor. It's one of the 6 factors that the court can consider in assessing that level of control. So in the case of Tremblay, the husband and his parents were trustees of the trust, and the husband, the wife, and their 2 children were the beneficiaries. And while decisions about the discharge of the trustees' obligations to the beneficiaries were to be made by the majority of the trustees, the husband had the sole ability to appoint more trustees. And so on the facts of that case, Justice Phillips ultimately found that the husband's ability to name additional trustees amounted to an ability to control the trust. And therefore, the husband's interest in the trust was property under the Family Law Act that was to be equalized. And Justice Phillips' logic was, even if the other 2 trustees, which in this case were the husband's parents, didn't agree with the husband and agree with the distributions that the husband wanted to make, the husband could simply appoint additional trustees that would side with him, and therefore they could outvote the other trustees. So again, we're looking at the actual control that the beneficiary can exercise over the trust. There are cases, however, where the court finds that a spouse does not have control over the trust, and therefore their interest is not property under the Family Law Act that is subject to the equalization regime. So this is more likely to happen in cases where the court finds that the beneficiary does not exercise control over the trust. There's one decision actually from 2016 called Kochar and Kochar, where Justice Aston very helpfully summarized this as saying, there is no legal precedent for the proposition that the beneficiary of a discretionary trust, without any power of appointment, has a proprietary interest in the trust for the purposes of the broad definition of property in the Family Law Act. So if you are ever looking to argue that your client's interest in a beneficial interest in a discretionary trust is not property, certainly that case will be very helpful to you along with that statement. And in that case, actually, Justice Aston concluded that the husband's beneficial interest in the trust was akin to the expectation of an inheritance, which the courts have consistently found not to be property subject to equalization. So now that we have talked about how to determine whether an interest in a trust is property under the Family Law Act or is not property, that then leads to the question of how do you, if you do determine that the interest is property, how do you go about valuing that interest? So we are going to we would be looking at a lot of the same factors that we were looking at in that first step. And it's not a straightforward exercise, but again, we're looking at things such as the intentions of the settlor, the fiduciary responsibilities of the trustees, the number of beneficiaries, and how the trustees have exercised their power in the past. So, for example, who have the trustees made distributions to in the past? What's the timing of those distributions, the amounts? Are they equal among all beneficiaries? Are they different? What does that look like? So those considerations will all inform the issue of valuation. So for example, actually there was a case from Alberta going back from 2000, but it does do a fairly thorough job of summarizing the valuation issues. But in that case, the husband had an interest in a family trust. He was a beneficiary. And the trustees of the trust were the husband and his 2 close friends. And the beneficiaries were the husband and the party's children. And so the court, in considering what the value of the husband's interest in that trust would be, they took into account the husband's evidence that he had created the trust for the benefit of the children. They considered that the husband had renounced his entitlement as a beneficiary of the trust. And they also considered that all distributions from the trust had been made to the party's children. And as a result of those considerations, the court ultimately concluded that the value of the husband's interest in the trust was 0. There are examples of cases where the court will or has valued a spouse's beneficial interest in a trust by simply dividing the capital value of the trust by the number of beneficiaries at the relevant time. So, for example, if the spouse is one of 4 beneficiaries and the value of the trust is $100,000, they would attribute a value of $25,000 to the spouse's beneficial interest in the trust. However, it's important to keep in mind that each of these cases are decided on the specific facts of the case, and so it shouldn't be assumed that the court will adopt that approach in your case. And there are some examples of the court taking that approach in the paper, including the decision of Segal and Segal. And so now that we've kind of gone over the background of how these issues are approached, I thought that I would spend a few minutes just talking about some of the practical issues that come up when dealing with this issue with equalization claims. So the first is, or practical advice rather. So the first is how to, now that you understand the difference between a deduction and an exclusion, and that if a party has received a beneficial interest in a trust prior to marriage, they don't get the benefit of the exclusion. How can you plan for that before the party actually gets married? And so the main way to go about planning for that and for trying to protect that interest from the equalization regime would be to do a marriage contract. And of course, these can be done after marriage as well, but they're typically done before the parties are actually married. So spouses can modify the equalization regime through a marriage contract. They can also opt out of the equalization regime altogether. In terms of modifying the regime as opposed to opting out of it altogether, it is fairly common for spouses to sign a marriage contract that provides for one spouse's beneficial interest in a trust that they received prior to marriage to be excluded from the calculation of net family property, as well as any distributions that they might receive during the marriage. So essentially what they're doing is they are contracting into the same benefits that they would have received if the family trust had, if the interest in the family trust had been given to them during the marriage as opposed to before the marriage. So essentially we're fixing that kind of weird quirk about the Family Law Act that distinguishes between when you receive the property. It's important to remember, however, that while this can be one tool that you can use to try and protect your clients, marriage contracts can be set aside by the court. And so to minimize the possibility of this happening, it's important that both parties have the benefit of independent legal advice, and that both parties make full, fair, and frank disclosure of the value of their assets and liabilities at the date of marriage or as close to the date of marriage as possible. So when you're dealing with a contract that deals with a trust interest, you want to make sure that you are providing disclosure regarding the trust, because it is important that the other party understands what potential rights they are contracting out of by excluding that interest from the equalization regime. So in the case of a trust, this would likely include a copy of the trust agreement, details of the trustees and the beneficiaries, including the number of beneficiaries, details of the assets and liabilities held by the trust, including the approximate value of those assets, and details of past distributions. And what we often see is that we will have a client come to us at the request of their parent, who is a trustee of a trust. And so in those situations, sometimes it may be necessary for you to meet with both your client and the parent trustee to explain the importance of providing this full disclosure, because your client may have difficulty conveying that to their parent. And again, that is not a step that can be skipped if you do want the marriage contract to hold up in court. Aside from a marriage contract, the easiest and safest way to protect an interest in a trust from the equalization regime is to ensure that the spouse receives their interest in the trust after the date of marriage by way of gift or inheritance, as opposed to before the date of marriage. And that will ensure that they get the protection of that exclusion. Therefore, so for any lawyers who are in attendance who do estate planning, if you have a client who comes to you who's looking to set up a family trust, I would encourage you to have some conversations with them about the beneficiaries, which presumably, or more often than not, I understand, would include their children, and the marital status of their children. So, for example, if they're looking to make their 3 children the beneficiaries of the family trust, asking them how old the children are they married? If they aren't married, may they be getting married in the future? And perhaps based off of those answers to those questions, you may suggest that they get advice from a family lawyer as part of this estate planning process. And so it's probably naive to think that someone would agree to put their estate planning or their estate plans on hold until their children get married. But it's important that they understand how the estate planning and the family law interact. Because, for example, they might be putting in place this family trust to save on taxes, not realizing that they're opening their child up to potentially having to, share the trust with their future spouse. And so it's important that they understand that as part of this estate planning process. And just as a final piece of practical advice, what happens if a spouse is a beneficiary of a trust that they received prior to marriage and they separate? The first step as a family lawyer is going to be getting information about the trust, because we want to be able to do that preliminary assessment of what is actually the structure of the trust, how is it controlled, how have distributions been made in the past, and are those likely to continue going forwards? And once you have that information and have done that preliminary assessment as to how the trust works and how much control your client as a beneficiary has over the trust, that will help inform how you handle this issue going forwards, including how you handle requests for disclosure, which as family lawyers, we know can be never ending. And so again, we're looking at producing likely a lot of the same type of disclosure that you would have produced as part of a marriage contract. So again, we're looking at a copy of the trust agreement, details about the trustees and the beneficiaries, and details regarding distributions from the trust, at least to your client. So even if you're not going to provide a full list of distributions, with what's likely relevant and producible is disclosure regarding the distributions that have been made to your client as the beneficiary. However, this can obviously be difficult because, again, we're dealing with this complicated matrix of family members where your client is likely the child of the trustee. And so they are likely having to go to their mother and father to ask for this disclosure that they don't already have on hand. So again, something that you may want to consider or that the trustee may want to consider as the parent, is retaining their own trust lawyer to deal with these types of disclosure requests, which, as I said, can be quite unwieldy and out of control. And it can be easier as a family lawyer to actually have, for example, a letter from the trustee's trust lawyer saying, we've reviewed the other side's disclosure request regarding the trust. Here's what we're prepared to produce. Here's what we're not prepared to produce and why. And I was just wondering, before we turn it over to questions, if perhaps David could speak about whether he has been engaged in this capacity in the past, or if it's something that he would be prepared to do going forwards, and what his thoughts are on that.
Thanks very much. I have done a number of these kinds of cases, and I think it's a very good idea for the trustees of the trust to retain their own counsel, given the fact that they have extensive fiduciary obligations. And from a trust lawyer's perspective, this raises a whole host of problems. It's one thing when you have a fixed trust that, a trust that provides fixed interests in usually money that's being held, and you can then value it, and you can say what belongs to what beneficiary. In a discretionary trust, things get really complicated. I mean, one, you may have a series of beneficiaries that don't know that they're beneficiaries of the trust, And the settler's intention was not to let them know that they were beneficiaries of the trust till a certain date. And so disclosure is a problem in that respect. You may have a working business that is the subject matter of the trust, and the trustees don't want to provide very much in the way of information because it might leak into the marketplace and prejudice the asset value of the assets that are under administration. There might be a letter of wishes that the settler has provided, which contains highly confidential information which should not be disclosed. And certainly, if it's going to be disclosed, it should be probably subject to a judge's order with some opportunity to have, if not proceedings in camera, but then have material sealed and all the rest of it to protect other confidential information. From my perspective, I would also add that some thought should go into whether, in fact, if the negotiations don't produce a settlement and it's necessary to go further, whether this belongs in court or whether this should be subject of an arbitration. Because the nice thing about family law arbitrations when it comes to trusts is you can preserve confidentiality a lot easier in the context of an arbitration than in a court proceeding. Things can be sealed and that's fine, but those orders are very difficult to get. And just the nature of the process is very difficult to control. So these disclosure points are things that trustees should be very much concerned about because there might be unanticipated liability or problems that are going to arise in the future vis-a-vis the other beneficiaries. And if you don't mind, Kristy, I just do want to go back and remark on something else that you talked about, and that is valuation. We see, as just a matter of trust law, lots of different kinds of valuation problems that arise, both in fixed trust and in discretionary trusts, particularly where you do have working assets. So everything's easy when you're just dealing with money or money's worth in terms of investments, because you can accurately value them on any given day. But valuation ultimately is not a legal question. It's an accounting question. And there are different ways to value assets, and, depending on their use and their intrinsic value and their market value. And if the trust instrument make it clear that the assets are never going to be offered on the market, or at least not until, some delayed time, and then being able to determine their fair market value for tax, family law, whatever, or tracing, where there's an issue about misappropriation or trustees breaching their fiduciary obligations, that gets to be really, really complicated. And so this is where it's not only a trust lawyer that might have to be consulted, but an accountant that is used to dealing with trust interests and can offer different types of analyses to valuing those assets. So there's a tendency to overvalue things, and that becomes a very complicating feature in something like family law, where the parties have very differing views of what the value of a trust interest might be. And having the opinion of somebody that's really familiar with valuing these kinds of interests might be helpful.
And certainly we work with business valuators in the context of our family law rule, but presumably, if we needed someone who had specific expertise in valuing trust interests, we could go to you, David, or someone at your firm, and you would surely be able to provide us with a referral for that.
100%.
Perfect. Yeah. And that's why, just touching on that last point, I just want to drive home that's why I think it's very important that the first step of the analysis is considering whether or not this interest in a trust is actually property to be equalized. Because if you think you have an argument that it's not property, then that's your response to a lot of those disclosure requests, including with respect to the assets and the liabilities held by the trust and any sort of request for evaluation. And ultimately, you won't know the answer of whether it's property to be equalized until you have an arbitrator or a judge weigh in. But that can be a complete answer to those disclosure requests, at least at that starting point. And then if the other side does bring a motion either against your client or a third-party trustee for the production of disclosure, the preliminary issue the court or the arbitrator will have to consider is whether or not this is actually property to be equalized, because they're presumably not going to order the production of extensive disclosure regarding the trust without first considering that kind of threshold issue.
Thanks.
So
I think Peter, I think we're ready to play Stump the Chump. Well, in my case, or put questions to the expert in Kristy's case.
Well, first off, thank you both very much for that presentation. As David mentioned, we can open the floor now up to any attendees that have any questions about today's topic. You can either just put your virtual hand up or just shout out and ask a question. Or you can write it in the chat, and we're happy to direct it to either David or Kristy. All right, we've got our first question here. I'll read this out. If the testator died leaving a will before the beneficiary was married, and the trust was to wind down after a number of years during the marriage. So the trust is winding down during the marriage, with the balance distributed to the beneficiaries. Would the distribution received by the beneficiary during the marriage and after separation be excluded in equalization? Do you want me to repeat that?
So it's okay. I think I understand what the question is, but if I don't hit it, feel free to follow up. And you can also reach out to me directly, of course, if you have any follow-up questions. But I believe the question is essentially if someone has a contingent interest in a trust that was received prior to marriage, but the contingency didn't fall away until after actually during the marriage. So the definition of property in the Family Law Act does still refer to contingent interest in property. So from my perspective, it would have been acquired prior to the date of marriage. And so it wouldn't be an exclusion, rather it would be a deduction.
Right.
So including any distributions received during the marriage, you would be required to share those as part of the equalization process.
Thank you, Kristy. I see Esther Mendelson has a question. Go ahead, Esther.
Thanks to you both for those presentations. So my question is, when settling a trust, is it best if a trustee who is not a relative of the beneficiary is appointed, if there's any sort of suspicion or feeling that a separation between the beneficiary and their spouse may be on the horizon, or is a possibility if there's any worry on that end?
Yeah, I don't think it's a bad idea. As I said, a familial relationship between the trustee and the beneficiary does not necessarily, it's not determinative of the issue. It's just one consideration. And I think this is actually, I'll touch on another question, which is, what happens if a party just essentially creates a trust, names their children as beneficiaries, but essentially just uses it as their piggy bank? So again, in that case, certainly the fact that it's a family member who is the trustee is going to impact, in that case, the actual use of the trust as well as the familial relationship would seem to point to the fact that it's the property owned by the trustee spouse as opposed to the children beneficiaries. So in going back to your example of would it make sense to use a kind of arm's length third party as a trustee? Again, it certainly wouldn't help or wouldn't hurt. And I think you have to also look at, are you talking about a parent as well as an arm's length third party being trustee? So the two of them are trustees. So then you're also looking at, do either or both of the trustees have the power to appoint additional trustees? Because then that gets back to the one case that I had cited where, it was the husband and his two parents who were the trustees, but the husband had the ability to appoint additional trustees. So by retaining that power, he was still retaining control over the trust. And then also it goes to and I mean, David may be able to speak to this more, but it goes to what the purpose of the trust is in the first place, right? So a lot of the time, these trusts are not set up with keeping in mind, how this will be treated in one of the children's divorces or separation. And so it goes back to what's the trustee's intentions, assuming the trustee is also the settler or, the one who had the idea to start the trust in the first place. How do they want to use the trust? How do they want to administer the trust? Would having an arm's length third party defeat those intentions? So I think those are all questions to ask, but certainly, that would be something that I would raise as part of that estate planning process to keep in mind what it would look like on separation.
Yeah, from my perspective, I would say this is where you're bumping up against sham trusts because, it's like the human rights provisions of the North Korea Constitution. Looks really nice, but perhaps it's not actually being reflective of reality. And so, if in fact you don't have a trustee at arm's length and are not acting in the way that a normal trustee would act, that they're using the trust property as their own piggy bank, you're going to have some problems establishing that there's a bona fide trust here.
Great. Thank you both for that. And I think that answers the question that immediately succeeded that one. So I appreciate it. We've got another question here where a beneficiary of a trust is named prior to marriage, but they're not aware of it until during the marriage or after separation. Will a court find that this is not property to be equalized? So that the key issue here is, the beneficiary doesn't know about the existence of the trust until during marriage or perhaps even after separation. What happens with equalization in that case?
Yeah, so I don't know that it's actually, certainly that wouldn't be determinative. So the fact that the beneficiary didn't know about the existence of the trust or that they were a beneficiary of the trust until marriage, that wouldn't be determinative of the issue. However, other questions we could ask from this is presumably if they didn't know the trust existed, they hadn't received any distributions from the trust. So that is something that we're looking at in terms of whether or not it's actually property to be equalized. And even if it is property, what's the value to be attributed to it, right? Because if someone's a beneficiary of a trust, but they've never received a distribution from the trust, you have to think about whether or not there would be any value attributed to that interest or not. So from my perspective, I understand, as David was mentioning, some of the complexities when dealing with the family trust and why a trustee parent may not necessarily tell the children beneficiaries about the trust for a certain period of time. But from my perspective, I think, again, that what's more important is the questions that you would ask arising from that fact scenario in terms of, obviously they probably don't have the ability to control the trust if they don't know about it or haven't exercised that control and haven't received distributions from the trust. So those factors are certainly relevant to that analysis.
Thank you very much. We've got a question here about determining, I suppose, the validity of a trust or the degree of control. What are some of the major factors to consider when assessing a beneficiary's control over property in a family trust when the named trustees are someone else?
So there's a number of, as I said, in the case of Tremblay, it's a 2016 decision. The court in that case, Justice Phillips set out, I think, 6 factors for the court to consider. So I'd certainly take a look at that, and they are set out in the one paper, or you can look up the Tremblay decision. But we're talking about things such as, whether the beneficiary, first of all, the intention of the settler. We're looking at the relationship between the trustee and the beneficiaries, if any, including, whether the beneficiary is a trustee. We're looking at whether they have the ability to appoint additional trustees, whether they have the ability to cause distributions from the trust or influence that, and whether they've done that in the past. So again, you're going to want to ask your client, or if you're on the other side, you're going to want to be asking these questions of the other side about, how has the trust actually worked in practice? So looking at the trust agreement is a good place to start in terms of looking at who are the named trustees and beneficiaries, and getting any updates on the trustees and beneficiaries. But you're also going to get a sense as to how the trust has actually worked in operation since it was created. And that will help inform your assessment of whether or not there's a level of control there.
All right, perfect. We've got time for at least one more question here. I hope either of you are excited to talk about the rule of perpetuities. So how does the rule against perpetuities factor into the situation? So specifically, if the trust is at its 21-year mark, is there any argument that it is actually not contingent or discretionary?
Oh, I love perpetuities law. Well, for those of you that don't remember the rule against perpetuities, or the headache that you got in law school when somebody made you learn it, the rule against perpetuities, just to remind you, is the rule against remoteness of vesting. And so there has to be a vesting period that is no longer than a life or lives in being plus 21 years. That's the perpetuities period in Ontario. So at common law, if something could vest outside of the perpetuities period, it was void. It never came into existence. In Ontario, we have a wait and see approach. So we wait and see till the end of the perpetuities period and then determine whether the trust is void or not. So perpetuities only exists then to hold whether the transaction itself is void or not. That is, whether the trust itself ever came into being or is voided as a matter of law at the end of the perpetuities period. So that only then will go to not as to whether the trust exists or doesn't exist. I can't imagine many contemporary discretionary trusts violating the perpetuities rules. I mean, if you take the life or lives in being, and that is going to be either the settler's life or the beneficiary's life or somebody else's life plus 21 years, that tends to be a fairly lengthy period of time.